Hello, I'm Brian Painter of the Oklahoman. The U.S. Supreme Court ruled Monday in favor of a Tulsa woman who was denied a job by clothing retailer Abercrombie Fitch after she wore a Muslim headscarf to the job interview. The decision was 8-1 in favor of Samantha Eloff, who was 17 when she applied for the job in 2008 at a Tulsa mall. Here with us today is Chris Castile, who has been covering the case in our Washington bureau. Chris, Eloff wore the headscarf to the job interview, but it was never discussed. Is that right?
That's right, Brian, and that's kind of the crux of this whole case. The whole reason it made it all the way to the Supreme Court, because she wore the headscarf. She's interviewed. There's obviously this look, what Abercrombie Fitch at the time called a quote look policy. A certain look that all of its employees had to have that were out front selling things, and you weren't supposed to wear any kind of hats or any kind of head guard. But she wears the headscarf to the job interview, and it never comes up. The interviewer never says, "Hey, we have this policy, that you're not supposed to wear anything on your head. Is that going to be a problem?" And Samantha Eloff, the teenager, never said, "Hey, I got to wear this. Is that going to be a problem?" So last year, at the district court level in Tulsa, Samantha Eloff won the case. But last year, the 10th Circuit Court of Appeals, which is the federal court of appeals, a level below the Supreme Court, said, no, really, it's up to the job applicant to bring it up. You've got to say, hey, I've got this, religious practice. Can that be accommodated? Well, what the court said today was the employee, the applicant, the prospective employee doesn't have to bring it up. But what the issue is here is that Abercrombie Fitch, which didn't hire her because of the headscarf and its look policy, they can't not hire somebody because they're motivated by some concern about having to, make some kind of exception to their policies because of their religion. It doesn't matter. The court said today it doesn't matter that they didn't know for sure that Samantha Eloff had to wear this headscarf for religious purposes. It was enough that they thought she might have to be accommodated, so they weren't going to hire. Here's what the court said. An employer may not make an applicant's religious practice, confirmed or otherwise, a factor in employment decisions.
Okay, so what happens now?
So what happens now, as I said, the 10th Circuit Court last year ruled against that. So now it goes back to the 10th Circuit. And basically what the Supreme Court told the 10th Circuit Court today was like, you evaluated this case using the wrong reasoning. So now you got to go back and look at this case again based on what we said today, which was that Samantha Eloff never had to bring this up. An employer cannot be motivated not to hire somebody just because they think they might have to make a special, dispensation for them based on religion. There was one of the business groups put out a statement today saying, this is going to be a legal minefield for employers. Are never going to be able to, not hire somebody now, whether it's religiously motivated or not. If they have some kind of religious practice, it has to be accommodated. But another attorney said, look, this really doesn't come up that much. This isn't going to be like some widespread thing all over the country. And I was actually kind of struck by that while covering this case, that, even though you've had like decades of, this law has been on the book for decades that you can't have, discriminate against people based on their religious beliefs in the workplace. This case this question has never come up about, who's supposed to bring it up. So, my take on that would be, and I guess what this lawyer said made sense to me, that this probably isn't going to happen that often.
Today's June 1st. This is going to be a busy month for the Supreme Court. What are some of the decisions still to come this month?
Yeah, Brian, there are some huge cases that we expect to come down in the next month. The court, at least for now, has only scheduled opinions on each Monday of June. So some pretty huge cases. That includes same-sex marriage. Whether states like Oklahoma, like any state, can ban same-sex marriage, and whether that violates the 14th Amendment to the Constitution. parochially, we've got the lethal injection case from Oklahoma. You know, the question of whether this alternative sedative that has been used by the state, you know, constitutes cruel and unusual punishment and lethal injection. You got the Obamacare subsidy case. That's an absolutely huge case too, for basically the survival of Obamacare. You know, which is whether in states where the federal government had to set up the insurance marketplace, whether you can still give tax subsidies to people who wouldn't otherwise be able to afford health care insurance. And, you know, for me, an interesting case, I think for a lot of people, is the Texas license plate case, the Confederate flag case. Anyway, after the case today, the Abercrombie Fitch, the headscarf case, those are the four that I'm really watching.
All right. Thank you so much, Chris, for joining us today from the Oklahoman's Washington Bureau.